I can go then. Good morning. The online meeting of the Windward Planning Commission will now come to order. It's Thursday, August 5, 2021. The time is 9:01 a.m. Based on the governor's 21st proclamation related to COVID-19 emergency dated June 7, 2021, we are holding this meeting online. This is to maintain physical distancing and to prevent the spread of COVID-19. The public can observe this meeting on YouTube live stream following the link provided on the county website calendar or by using the URL advertised on the agenda. The video recording will be available on the same YouTube channel. Minutes and transcripts will also be posted on the county website at a later date. I'd like to remind all participants the protocol for this meeting. Silence your phones and any other devices near you. Only one person may speak at a time, so raise your hand to be recognized by the chair before you speak. Speak directly into your microphone and keep your microphone muted while you are not speaking. If you talk over each other or if your microphones pick up noise, the dialogue cannot be transcribed. Thank you for your cooperation. With that, I'd like to introduce my fellow commissioners. Please raise your hand when you are called. Commissioner Dean Au.
Morning.
Commissioner Gilbert Aguinaldo. Commissioner Joseph Clarkson. Commissioner Michelle Galimba. Commissioner Dennis Lynn. And Commissioner Thomas Rapafy. And I am Chairperson John Replogle. We do have a quorum required to hold this meeting. Also in attendance are Deputy Corporation Counsel Malia Hall, attorney for the Commission, Deputy Corporation Counsel Jean Campbell, attorney for the Planning Department, Deputy Planning Director Jeff Darrow, Planning Program Manager Maya Jackson, and Windward Planning Commission Secretary Melissa Dacayanan Salvador.
Morning.
Commissioners, I trust you have received and reviewed the minutes of the July 1, 2021 meeting. May I get a motion to approve?
So moved.
It's
Second.
been moved by Commissioner Rapafy and seconded by who? I'm sorry, I didn't see. Dean Au. All those in favor of accepting the minutes, please say aye.
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 Aye. Opposed?
Aye.
Opposed? Aye. Okay. The ayes have it and the minutes are accepted. We have one testifier registered to give oral testimony for item number 2, connections CBESS SPP 12-138, Henry Leloy. I ask that you limit your testimony to 3 minutes. Also, I would like to remind you that your testimony should be limited to the procedural question before the commission today and should not include testimony on the merits of the application.
Mr. Chairman, point of orders.
Yes, please.
Um, as I stated in the last month's meeting, I will have to recuse myself from hearing this agenda item. And being that this is the only item that will be discussed today, I request that I be excused from the meeting.
Oh, you. Yes, you may be excused. I thought it was very good of you to show up today. Thank you very much, Thomas. You are excused.
Thank you, Mr. Chairman. Thank you all.
Have a good day.
Too.
Okay. So testimony to the merits of the application. After your testimony, please log out of the Zoom platform and switch to the YouTube channel if you wish to observe the meeting. This is to limit the number of participants on screen in order to better manage the meeting and also minimize connection disturbance and noise. I am going to swear you in. Please raise your right hand. Okay. Do you swear to affirm to tell the truth before the Windward Planning Commission?
Yes, sir.
Please state your name and the town you live on prior to your testimony. And you may begin.
My name is Dr. Henry Leloy. I'm a retired physician in Hilo, Hawaii. It is important that this commission know and understand that never has anyone spoken against the existence of Connections Public Charter School. To be clear, we are opposing the development of a public charter school on Adita Street entrance road for multiple safety reasons that have been or will be iterated via oral or written testimony. A school of this magnitude is inappropriate for the proposed location. I will address water usage estimates and the availability of potable water from the Department of Water Supply, henceforth DWS. The project acknowledges that the maximum potable water allocation by DWS for development is 4,200 gallons per day.
Excuse me,
In
sir.
its application form, based on 60 gallons per day per student standard, a 4,200 gallon allocation could support 70 students. The Intermediate Court of Appeal
Chair.
decision questions
Chair.
where the 60
Point of order.
GPD per student
Excuse me.
standard came from.
Excuse me, Mr. Leloy. Can you pause? Your testimony is supposed to be in regards to the documentation, not problems or issues concerned with the school being there or not being there. We're here today to decide whether to allow new public testimony in or to continue and use testimony already provided. And
Let me just
those,
clarify that, sorry.
go ahead.
Chair.
Yeah, no,
Miss-
please.
Yes, Mr. Leloy, basically, this is only for a procedural question today on whether we are going to open up the record or just make a decision. The commission will be making a decision on the record. So if you would like to testify on the merits of the application, that will be happening at the next hearing. We'll have an actual hearing where you can testify to those things. But at this point, we are not hearing testimony on the actual school itself, just on the procedural question of whether the commission should make a decision on the record as presented or open up to limited evidence.
Okay. On the procedural question, would my testimony given regarding clarification on the figure of the student standard be relevant to today's meeting?
I don't believe so. The question today is, should we, the commission, and please correct me, Ms. Hall, should we, the commission, take what is on the record and use that to make a decision as to whether to allow the school to be or to say, no, we can't do that? Or should we allow the record to be opened? And now, like you're testifying just now, you could do that at the next meeting if that's what we decide. So you would be speaking either for going with the previous testimony and not opening it up, or you would like to see it reopened, and why? I don't know if that was real clear, but I hope so.
I guess I feel my testimony would support the fact that the findings of fact are legitimate, and that there is already evidence within that has been given, but it needs clarification, and that's what I'm trying to do. As the circuit court had remanded it to the commission, I was trying to help clarify that for them, which would help whether it needs to be either used as is or open up for more testimony, I guess.
Okay. However, your testimony is facts of things, as you said, that have already been stated and are in the record. Is that correct?
Yes, there
Okay.
are, but I think it needed clarification of where that student standard came from, which was not mentioned, which is what the Third Circuit Court of Appeals asked for.
Okay, and I think possibly it would be okay to address that. I don't believe we need to hear about the gallons of water or any of that. But I do believe if you have a point to make in regards to reopening the hearing or going with what exists, we would appreciate hearing that.
Okay. Could I proceed then with just trying to address that?
Yes, I don't want to cut you off, and you made the time. I would like to give you the opportunity to make your point. Should we go with what's already been stated? And if that's what we, the commission, decide at the next meeting, what you're talking about today would be totally relevant.
If you decide, I'm sorry, Mr. Chairman.
Yeah, if we decide to go with what's on the record at the next meeting, what you were saying to us about the water and all that, you're refreshing those important points in the decision that was made. Okay. And that would be great to hear at our next meeting when this will be on the agenda. If it's decided to be reopened to fresh testimony, you could still make your presentation in the form you were attempting to today. I think I'm getting that correct.
Well, I think my testimony today may be relevant, and it may apply to either you go with the current testimony or whether you open it up. So I think it would be relevant either way.
Okay, which would you prefer it to be? That's the question today that you should be supporting.
And you're asking, I'm sorry, what are you asking me again? Sorry.
Anybody wish to say? What I'm trying to say is, if today you say, I don't think we should open
Chair,
it up to
Chair.
new, fresh, yes.
Counsel for CBES has his hand up.
Oh, I'm sorry, may I see your, oh, okay, Mr. Hong, please.
Thank you. I was just informed by the attorney for connections that
Yes.
for some reason his link is not working, that he can't get into the Zoom hearing. Deputy Attorney General Carter Sue. So I was wondering if someone from the planning department of the commission could send him Mr. Sue a link. Oh, there he is. Now he's connecting. Thank you. The other thing that I did want to mention is, again, this is a procedural issue, and Mr. Leloy is trying to pollute the record again by putting in additional facts that we are, if the chair is going to allow that, then we are entitled to rebut those facts, and this now reopens the entire hearing. So, I would suggest that the chair and the commission abide by its agenda and have him either address the procedural issue, reopen the hearing, have it be a do-over or not. And if without getting into the facts, because once we start getting into the facts regarding the per gallon and all that kind of stuff, if Mr. Leloy is going to get into that, we're entitled to rebut that.
I
Thank you.
agree with you, Mr. Hong, and that's what I'm trying to clarify for Mr. Leloy. So, and I think you helped me there. So, Mr. Leloy, it's the procedure, not the gallons. Do you want it to just stay as it is, or do you think it should be reopened to new public testimony? That's your options here. We do not wish to hear about the gallons or any of that.
Chair, I
That
think
will be at the
Mr.
next
Clarkson has
yes.
a question.
Mr. Clarkson, go ahead.
Yes, I'd just like to ask our Corporation Counsel a question to clarify this issue. If the commission decides to make its additional considerations only on the record, will testimony of any kind be allowed? And if so, by the public? If so, what kind of testimony would be allowed?
You're saying if you guys decide to make a decision on the record? As it
Yes, I
presented?
think it's unclear to Mr. Leloy and to me from what you said earlier and what Chair Replogle is saying.
Well, state law
whether
and
any
also your
testimony- Okay,
state law and planning commission rules require that the commission take public testimony. So plus public testimony will be given. With that said, if the record is as presented, you guys will be making a decision on the record as presented.
so we're required to take testimony, but if we decide here today to only make a reconsideration on the record, we will be disregarding all of that testimony. Is that the case?
Yeah.
Okay, thank you.
Okay, once again, Mr. Leloy, for keeping the record as it is and proceeding at the next meeting with that, or would you like to see it open to new public testimony? So someone who didn't testify in 2014 could come and testify at the next meeting for or against the school, but they would be new testimony.
Chair, sorry.
Yes,
It's not
please.
just public testimony. It would be new evidence. It would be
Okay.
the applicants and would also be able to. So Mr. Lila, the question is basically, do you want them to make a decision as on the record that has been already presented, or would you like new evidence to be entered into the record?
Okay.
There you go.
All right. Thank you, Chairman, Commission members, and Council. I appreciate your time, your efforts to volunteer, and those of you are uncompensated. So what I'm going to do is just defer that decision to the chair and the commission, and I guess that's their job. So I no further comment from me, sir.
Thank you very much, Mr. Leloy.
Should I leave?
Okay. You may go to Zoom. Excuse me, not Zoom, but YouTube, if you wish to watch and follow the proceeding from this point on.
Very good. Have a good day, everyone.
Okay, thank you. Okay, commissioners, may I hear a motion to close public testimony, please?
So move.
It's been moved and a second by Mr. Lin and a second
Second.
Seconded by Commissioner Au. All those in favor, aye.
Aye.
Aye. Okay, the ayes have it. Public testimony is closed. So we had one item on new business, Hawaii Island Humane Society. And the department returned the amendment application as it was deemed unnecessary. So this item will not be heard. So we're going to move on to unfinished business. And the applicant is Connections New Century Public Charter School Community-Based Education Support Services, CBESS SPP 12-00138. Discussion and action limited to the procedural question on whether the Windward Planning Commission will make a decision on the record as presented or open the record to hear new evidence regarding special permit SP number 12-00138, which was remanded back to the Planning Commission by Intermediate Court of Appeals for further proceeding consistent with its January 31st, 2020 memorandum opinion vacating the County of Hawaii's Windward Planning Commission's May 12th, 2014 decision and order, which denied special permit SP number 12-00138. The subject special permit sought to develop a K-12 charter school campus with dorm facilities and related uses on approximately 70 acres of land situated in the state land use agricultural district. The property is located on both the southwest and northeast sides of Edita Street, near its intersection with Kaumana Drive and adjoining the Pacific Plantation subdivision in Kaumana, South Hilo, Hawaii, TMK 2-5-006-141. There will be no presentation at this meeting, as it is only to decide if the commission will make a decision on the record or reopen the record. A presentation may be given at the next meeting. The following parties are present. Please state your name and who you represent.
Chair, point of order, please. I have a question.
Yes, please go ahead.
Could I go ahead and make a motion to go into executive session? I have a bunch of questions. Before we hear the applicant, I have questions for our counsel. So I move to go into executive session.
Can I have a second? Okay, we have a
Second
second. Oh, I'm sorry.
Yep.
What am I doing now? Okay, all those in favor of a brief executive session, say aye. Aye.
Aye.
Okay, we will go into an executive session. I don't know how that works on Zoom. I'm assuming
Chair
Ms.
Replogle,
Jackson.
yes, I'm going to go ahead and move the commission as well as Ms. Hall and your secretary into a breakout room. So just
Okay.
give me a few minutes to set that up.
Okay, thank you. And thank you for your patience, testifiers.
Aye. Oh. Sorry.
Okay, sorry about that, folks. Let's try this again. I have to pull everybody back out into the main session so that I could give Melissa permission to record the executive session. So let me reassign everybody from the commission back into the breakout room. Give me just a moment. Okay, here we go. Hi, Ted. I just saw your chat message. Is Mr. Garcia identified as Damon? I have somebody in the waiting room named Damon. That's the only identifier I have.
I know what's going on there. This is John Thatcher. They couldn't get Mr. Garcia's computer up, so they're using a different computer.
Okay, thanks. I'll let him in.
Okay, thank
you.
you.
Appreciate it.
Chair, you're muted.
We're back in session, and thank you, applicants, intervener, and planning department for your patience. I'm going to swear you all in together. Please raise your right hand. These are yes, okay. Do you swear to affirm to tell the truth in this matter before the Windward Planning Commission?
Yes.
Okay, we good?
Yes.
Please say yes or, okay.
Yes.
So,
Yes.
thank you. So we will begin with the applicant's connections, and CVESS will both be presenting. Please begin.
Good morning, Mr. Chairman, members of the Planning Commission. My name is Ted Hong. I represent CBES, the Community-Based Education Support Services. That is the nonprofit parent entity of Connection School, the governing board. You have my letter that we submitted pursuant to the board's July 6, 2021 letter. With me this morning, on behalf of CBES, is John Thatcher, the retired principal of Connections. He's there with the green wall background. You have before you my letter of July 28th, 2021. We certainly would be more than happy to answer any questions that the chairman or the commissioners may have regarding our position on this matter. And I believe Mr. Carter Sue would like to say something. Thank you.
Thank you. Mr. Sue?
Good morning. This is Carter Sue on behalf of Connections Charter School. I just joined in Mr. Hong's brief, and that's it. I think I submitted something as well, but yes, I concur with Mr. Hong.
Mr. Chairman, if I may note, also present is Romeo Garcia, the present principal of Connections Charter School, and he has several students watching as well.
Thank you. Okay, and your position is to stay with the program.
I think Mr. Matsukawa wanted to say something.
Okay. The intervener, Mr. Matsukawa. You have the floor.
Yes, I just wanted to let the commissioners know that we stand on our brief that we had filed earlier and have nothing in addition to add other than to help the commission understand the effect of a remand. The court cases hold that when there's a remand, the court from time to time makes a statement of the law or a particular point, and that's called the law of the case. And that statement, which is the law of the case, becomes exactly what it is. It's the governing law against which we all have to function on remand. Thank you.
Okay, thank you. The planning department. Do you have anything to say?
We also submitted our position, and at this time we take no position on the matter.
Okay, thank you. And applicants, do you have any points you would like to address before I open questions from the commission?
Thank you, Mr. Chairman, members of the commission. Again, this is Ted Hong on behalf of CBES. You know, the only point that we want to make this morning is, again, that we feel that a reopening or redoing the hearing, the contested case hearing, would unnecessarily delay the project, because that would be essentially in violation of the Kuhonua Hawaii State Supreme Court's decision on what an administrative agency should do on remand. And I think at this point that there's been a lot of information provided from the parties, and I would suspect that the commissioners may have some questions, and I think Mr. Su and I would be more than happy to respond to any questions that the commissioners or the chair may have. Thank you.
Thank you, Mr. Hong. Is there anything else? Okay. I'm going to move to a motion for action. Well, actually, we're going to open it. Yes, Mr. Clarkson.
I was prepared to make a motion for action, but if I'm premature, let me know.
No.
Okay. I move that the commission open the record to hear new evidence limited to the following. Those items in the appellate court's opinion where they suggest additional findings and additional hearings might be necessary. There being several.
Okay. Do we have a second?
I'll second that.
Okay. All those in favor of this motion, please signify.
Chair, point of order.
Should be a
Discussion.
vote. Yes, go ahead.
There should be
Ms. Hall.
discussion, Chair, and then a roll call
Okay.
vote after discussion is finished.
Okay, thank you. Mr. Au.
Thank you, Mr. Chair. I just have a question for Commissioner Clarkson and Commissioner Galimba regarding the motion. The way the motion stands right now, I don't support it. I think we have enough evidence to make a decision. Obviously we're going to hear from both sides, from both attorneys, but I think we have enough evidence. But I would still like to hear other commissioners and even Commissioner Galimba, Commissioner Clarkson, why you're making that motion. And but the way I stand as of now is I don't support the motion, but I do want to hear from all the commissioners regarding this motion. Thank you.
I would tend to agree with Mr. Au. I think we have sufficient information within the court's document as well as this on the record. And I believe that would, it would cost a lot more money and time for everybody else to go through this whole process again.
Thank you. Mr. Clarkson.
I'd like to just speak briefly in favor of my motion. I just noted, at least in two places, page 42 of the opinion, where the appellate court notes that without additional findings by the Planning Commission, the Planning Commission's findings of facts 59 and 62, finding that the development would be contrary to the general plan are arbitrary and capricious. So this seems to imply consideration, including additional findings. Now there may be a legal term, a legal meaning for findings there that I'm missing, but I would think it would include evidence. And then on page 43, the appellate court talks about why they may remand, and they refer to the Lanai Company Inc. versus Land Use Commission case, where a case was remanded to the LUC for additional findings and conclusions and further hearings if necessary. So it seems to me that what I would call the rather vague conclusion. Where is it? Where they say, where the court said this case is remanded to the Planning Commission for further proceedings consistent with this opinion, that they're obviously opening the door to new evidence and a reconsideration and testimony about old evidence. And that if they wanted us to restrict ourselves strictly to the record, they could have easily said so and didn't. And in fact, made at least 2 references to additional findings and possible hearings. That's why I think certain things, especially the lack of evidence in the record for the water use criteria that was discussed in the previous commission's decision, I don't see how that can be resolved without additional evidence from an additional testimony. There's numerous things like that. What is the importance of notifying all the people within 500 feet of the project? Whereas the appellate court talked a lot about the meaning of community and whether there should be differential consideration of different parts of the overall community. And so I think that there are a lot of issues that need to be covered before the commission can make a non-arbitrary and capricious decision. Thank you.
Thank you, Mr. Clarkson. Mr. Au, any thoughts?
Yeah, I'll just respond to Commissioner Clarkson's response. I think that's fair. That's your opinion and you would like to hear that, and I respect that. So after those comments, I'm on the fence now, but I would still like to hear from the other commissioners.
Could I speak, Chair?
Yes, Ms. Galimba.
So I guess I would like to ask a clarification on that, because I agree with Commissioner Clarkson that we need to be able to very clearly articulate our reasons for either supporting or rejecting the proposal. And there were those points that Commissioner Clarkson mentioned in the order that requires our, fairly detailed attention. So I guess the question I would like to ask is, would we need to open it to more evidence, more testimony to do that properly? Like specifically the general plan question that Commissioner Clarkson brought up. So I guess I'm asking council that question. In your opinion, is there enough evidence in the already existing documentation to do our job properly as far as articulating our decision?
I guess let me frame it this way. I do not think that the remand from the ICA commands the commission to open the record. I'll say that. I say that it leaves it open-ended. On if you guys need additional evidence, I really can't speak to that. I think that if you guys have read through the entire record and you're prepared to make a decision on that record, then there's no need to open the record. And then, the other one, if you feel like you're not prepared to make a decision after reviewing the whole record, then you may open for limited testimony. But I would advise on that motion is very broad, and that it should probably be much more specific as to what specifically the commission is looking for to supplement the record.
And we should state that, so that would be opening it only to those topics.
Yes.
Okay, thank you.
Well, if I may amend my motion then, that it should be reopened only for those items that the appellate court, only those items in the original commission decision that the appellate court vacated.
The entire decision and order was vacated, Commissioner Clarkson.
All right, well, what do you call those items that were specifically noted by the appellate court then?
We would need the specific subject areas. The court did highlight specific findings of fact that they felt were not supported.
Right.
But that doesn't necessarily mean that you couldn't support them with evidence that is already on the record. But that's up to the commission if they feel like an approval or denial can be supported by the existing record.
Well, it's
Mr. Clarkson, yes.
Yeah, it's clear that the record did not support, in fact, the court could find no evidence in the record to support a particular number of water use per student requirement. And so therefore there clearly isn't enough information in the record for us to reconsider that. I think we need to get evidence as to where that 60 gallons per minute came from, or what a new or current value might be. And I don't see how we can get that number simply by looking at a record where the court declared that the information did not exist.
Okay.
So Commissioner Clarkson, do you want to limit your motion to that specific topic, which I think would be very valid, as you point out. We have heard since then where that came from, but it isn't in the record of the original case, I believe.
Well, I'm sorry, I'm remiss. I'm not prepared to list the specific topics that we should be limited to. I didn't think it would be required that if we opened it up to any new evidence, that would be a fairly broad category, covering numerous items that were discussed in the opinion memorandum. If the rest of the commission would like much more specificity, then I'll have to ask for their patience in letting me go through and find all the findings and other decisions that the commission made that were deemed unsatisfactory by the court.
Mr. Chair, I have my hand raised.
Oh, I'm sorry, Mr. Ao, please go ahead.
I would still like to hear from our honorable chair on his opinion, and I still want to hear from Commissioner Algrenado, but before you do that, I would like to respond to Commissioner Galimba's question to Commissioner Clarkson. If we open up the record, I don't know what the consequences are going to be if we just limit it to 1 or 2 or 3 things. It's either we open it or we don't. That's my feeling, Malia. Ms. Hall, maybe you can interject on that, but I still want to hear from my fellow Commissioner Gilbert Aguinaldo and our Honorable Chair, Rep. Logo.
Mr. Aguinaldo? What say you?
I just think that from based on what is being discussed, you know, I just truly feel that, you know, we can proceed in moving forward, but to an extent of, again, with our fellow commissioners, on that, you know, once you open the can, you know, that's the thing, right? If we have enough sufficient evidence to move forward, let it be. And if not, you know, what is the count of, you know, the limit count of, you know, the questions, right? What are we going to talk about?
Thank you. Your Honorable Chairman thinks that we should stick with the record as it is. I think opening the record, as been stated, is opening it. It should either be opened or not opened. And the court made its decision based on what was presented the first time. And I don't know that we should be opening it back up again, where it's been quite a few years and we're dealing with that. Time and space is the question. So I don't believe we should open it back up to new testimony. I think we should go with what we have and make our decision. Mr. Lin.
Chair, I'd like to call for the question.
Okay.
So I'd like to call for the vote on the motion that Mr. Clarkson presented.
All right.
Mr. Chair.
Yes.
Please, before we make the vote, I would like to get Ms. Hall's procedural, what's going to happen if this motion gets voted up or voted down. Can you just explain to us what may or may not happen?
So if the motion passes, then the record will be opened, and then the next hearing, there will be public testimony. The applicant intervener will present their arguments, and then if the commission so feels that they have enough information at the end of that testimony and that argument, then they can make a decision at that time. If you vote against it, then we need a new motion for whatever you so choose, and from there we go from there. And then I can advise you as to what the procedure will be on for that.
So Ms. Hall, can I make a motion, a separate motion to move that the commission make a decision on the record as presented at our next meeting?
We have to deal with the first motion first.
Yes.
And then, if we have to see if that, unless there is a motion, or unless Commissioner Clarkson wants to withdraw his motion. But at present, we have a motion on the floor that needs to be.
And we should decide on that. Okay. All those in, wait a minute. It would be a roll call vote for this?
Yes.
Okay. So Commissioner Clarkson, correct me if I get this wrong, but Commissioner Clarkson would like to have the record reopened so we can address issues that the court outlined as needing more information. Okay,
Okay.
so staff,
Commissioner Clarkson,
Aye.
Commissioner Galimba,
Aye.
Commissioner Aguinaldo,
No.
Commissioner Au,
No.
Commissioner Lin,
No.
Commissioner, I'm sorry, Chair Replogle.
no.
Okay, the motion fails 4-2.
Okay, now Commissioner Lin, if you'd like to make your motion or
Sure.
whatever it was you were considering.
I move that the commission make a decision on the record as presented at our next commission hearing.
Second.
Moved and seconded to hear the evidence as presented initially and make our decision based on that. Any discussion?
Mr. Chair,
Yes, Mr.
I'd
Owl.
just like to state that I support this motion that I seconded for the reason that I believe that we have sufficient evidence and we can go into detail on each line item if the attorneys choose to do so. And with that, based off that information, I believe that we can still make make the best decision that we can. But I just wanted to clarify that for the record.
Thank you. Anyone else? Mr. Clarkson?
Yeah, I'd just like to speak against the motion by reiterating what our counsel told us earlier, that if we vote in favor of this, the record as presented, I assume it will be the complete record, will be the only basis on which to discuss any future action, and that all testimony from the public, presumably from the parties, from the planning department, will be disregarded by the commission because it's not already on the record. So we will be, I guess, reviewing the record separately on our own time, and then discussing the record in our next meeting in order to make a new decision, but without any ability to clarify any point within the record with additional information.
Mr. Chair, I got a question for Ms. Hall.
Go ahead.
So
Mr. Owl.
So Ms. Hall, just to clarify or confirm or just to make sure for my peace of mind, Commissioner Clarkson is stating that that we won't be able to hear the applicant, but I believe we will be able to talk to both applicants and the applicant's attorney. Is that correct?
Yes.
Okay, well, I believe through that process, things could get mitigated. You know, the attorneys and the parties could work on their own to figure things out. You know, this has been a long haul for all parties, for the community, for the applicant, and you know, we're giving them a shot to work it out, and whether they do so, it's up to them. But you know, but for our hearing, we're only going to hear what was already on the record. So I hope that addresses some of your concerns, Commissioner Clarkson.
No, it.
Mr. Clarkson?
it does not address my concern because there's a contradiction between what I understand the record to be and the fact that additional discussion will be added to the record at the next meeting by the applicant and the interveners and others. Are we going to add information to the record, or are we going to strictly consider the written information that's in the record? That's what I'd like to know. I thought we should be able to add it, but the commission obviously disagrees. So I'd just like to know what that means. Will the applicant be able to speak to interpret the record again in our additional hearings? Or will we only, and I don't know if that's the case, why that wouldn't be the same as opening the record for new information?
I think that's a fair question. Ms. Hall, can you answer that for us?
There's a distinguishing between allowing the applicant to speak to their original arguments and their original application, and that of bringing in completely new facts that are not on the record. So if the applicant so chooses, they will be able to present on the original application as is with no new facts, as will the intervener be able to present on the original facts with no new facts.
Mr. Lin?
So Ms. Hall, the clarification would be that the applicant and as well as the intervener could make clarifications based on what the record states. So we could ask them questions about, certain points that were made on the record pertaining to their portion. Is that correct?
Without the introduction of new facts, yes.
Okay. So as an example, I'm sorry, go ahead, Ms. Galimba.
No, sorry, I think you were probably gonna, I was confused about this interchange right now, so.
Okay, so
right.
if I understand this correctly, I'm just going to pick a topic, water, because it was mentioned. Both the applicant and the intervener can talk to the water question, but they can't add anything new like, oh, we got another 100,000 gallons coming from Kauai High. That wasn't in the original record, so you can't add that. But they can address the water as they understand it to make it clearer. Is that correct?
Yes, they can present the fact that the information on the record is sufficient to make a decision to whichever way they
Okay.
feel.
All right. Thank you.
Excuse me, Chair. I just don't understand that, but because the appellate court has already said that the information on the record is not sufficient to determine whether the commission's action was arbitrary and capricious or not. So if we restrict, and we have restricted ourselves to the information in the record, we are declaring that we must only make an arbitrary and capricious decision on this matter. I mean, to me, following the court's logic, we're stuck.
I'll address that, Commissioner Clarkson. That's basically what the applicant and the intervener will argue to, is whether you are stuck or not, whether that you need that information to approve or deny the application. They will make their argument on the present record. So, I mean, I don't want to go any more deeper because I don't want to give you an idea either way or represent either argument, but I would just say that will be they their job will be to show you that there is sufficient evidence on the record to present to support their arguments for approval or denial.
Thank you. So I'm sorry here, but I'd entertain, we have a motion on the floor? Okay. And Mr. Lin, would you restate it, please?
Move that the commission make a decision on the record as presented at our next commission hearing.
Okay, thank you. Roll call, please.
We
Commissioner,
need a second.
Oh, it was moved and seconded. I
Okay.
just wanted you to refresh everyone.
Okay.
Commissioner Lin,
Aye.
Commissioner Au,
Aye.
Commissioner Aguinaldo,
Aye.
Commissioner Clarkson,
No.
Commissioner Galimba,
No.
and Chair Replogle.
Aye.
Okay, the motion carries 4-2.
Chair,
Yes,
I would just want to remind the commissioners, you must review the entire record, all the transcripts, everything that was given to you, the court record that back from the very beginning of the hearings. Yeah.
okay.
Chair, I believe Mr. Hong has something to say.
Oh,
Mr. Hung,
Thank you, Mr. Chair and members of the commission. This is regardless of which side you're on this issue, the record is very comprehensive. It's a lot of information. May I respectfully suggest that instead of setting the next hearing on this issue for September, that a little bit more time be given for the commissioners to review the record, because again, it is quite comprehensive and lengthy. Several days of a contested case hearing, several days of actual commission hearings. Excuse me. So may I suggest that if the commission is going to set this for the hearing, then maybe it be extended, that hearing date and time be extended out a bit.
thank you, Mr. Hung. Mr. Masakawa,
Following what Mr. Hong had to say, I was wondering if your staff could work it out with the appellate court, because the original record, to my recollection, was filed in a digital format that can be retrieved by everybody. But since the appellate court has closed the case, we can't get access to it unless we go to eCocoa, and we have to pay, I think, $5 to see it. But if somehow they could make it available, and then everybody can look at that, because that was the record that was filed at the Intermediate Court of Appeals. I don't know how the procedure works, but it would be helpful.
Yes,
thank you.
the record will be made available because it will be part of the board packet. And therefore it will be posted wherever that gets posted, Jeff or Maya.
The digital format, the one that went to the ICA, would be great.
Yes, we post that on our website under the planning applications, and then we will send a Dropbox link to the parties as well as the commissioners.
Okay. Regarding Mr. Hong's suggestion that we maybe not take this up in September, any, Mr. Owl?
I understand all the commissioners here are volunteering. And, you know, I appreciate Mr. Hong's comments, but, you know, this is what we signed up for. So I think we should plug through and do it in September. That's my opinion.
Yes, Mr. Clarkson.
How many pages of documents are in the record that we're talking about here?
Mr. Hong? Do you know how many pages roughly?
Well, no, I will say too many, probably. We killed a lot of trees. But it is quite extensive. I'd say there were probably easily tens of thousands of pages of documents, including transcripts.
Yes, I'd just like to respond to Commissioner Au's suggestion that I personally will go on the record now as saying that I will not be able to review tens of thousands of pages of documents by September. And that if asked to, I'll have to recuse myself because my judgment will be ill-advised.
Okay, thank you. Anybody else have a thought on this?
Or would somebody like to make a motion to continue until a later date or the call of the chair? Or October? That way you can have a proper discussion.
Mr. Chair, I'll make a motion.
Mr. Au?
So I move that we push it back to the October meeting. If Mr. Clarkson, it feels that that's sufficient time, either to review the many pages, tens of thousands of pages of documents.
Second?
Do my best.
I'll second.
Okay, it's been moved and seconded that we move the next hearing on connections to the October meeting, which would be in the first week of October, Thursday.
Staff, could you confirm that date for the record, please?
Yes, that would be October 7th.
Thank you.
And are the attorneys and other people able to do that? I don't know.
This is Ted.
Go ahead.
Well, I'll make myself available.
Okay,
Hi, this is Carter Sue. I'm available.
okay, thank you.
October 7 is fine with the intervener.
All right. All those in favor of, well, the motion is moving the connections hearing to the October 7th meeting instead of September 2nd. All those in favor? Aye. Or raise your hand. Okay, it's opposed? Okay, so this topic will be taken up on October 7th in 2 months' time, basically. Mr. Clarkson?
I just have one more question as to what format the documents will be in that we will review, and will they be in a format in which we can highlight and make notes, marginal notes, without printing them out?
I cannot answer that.
Commissioner Clarkson, we usually send you a Dropbox link, and that Dropbox link attaches to PDF format documents. So if you have the ability to edit in Adobe, then you would be able to make those margin notes.
I only have Acrobat Reader. Can you clarify whether that's sufficient to make notes and to highlight items of text?
I think Acrobat Reader does have that capability, but I will check on that and verify and then work with you to get the information to you in a format that you can make notes on.
Thank you so much.
Yeah.
Mr. Matsukawa,
I just
sorry.
wanted to ask a practical question. I understand that the planning department has the record on its site and will be made available to us. Is there someone gonna check whether what went to the ICA is the same thing that's posted on the county website?
Yeah, we can verify that. The planning department is the one that created the record to be sent to the court in the beginning. So I'm trying to just think if it will have the ICA numbers or just the circuit court numbers, but I can double check. It'll be the same record, but maybe different page numbers.
Right, that's what I was trying to get. I remember there's some slight changes in the presentation, but if the documents are the same, then no big.
Yeah, they should be the exact same documents. They just might be numbered differently. Yeah. But there will be an index.
Okay. Thank you. You will be notified in writing of our, or be notified of our decision in writing. And we are going to move on to administrative matters now. Staff, are there any administrative matters?
No, there are not. And normally we send out the SMA log, but we did not send one out this month, and I apologize for that. We are in the middle of this transition from our old Excel log that we kept to the new Epic permitting system. So if it is okay with the commission, I would like an extra month to create a new log. We need to learn how to do the log format in the new Epic system. And then hopefully for your October meeting, we will have that SMA log for you, which will show information from July, August, and September.
Sounds reasonable. Any
Thank-
objections? Okay,
Thank you.
so we don't get confused. The Windward Planning Commission's next monthly meeting is scheduled for Thursday, September 2nd. And it'll be on Zoom as well. If there is no further business, may I hear a motion to adjourn the meeting and a second?
Mr. Chair, I have a question for staff.
Oh, please.
Just want to ask, I got two questions. Number one, is how much items are in the September agenda? And number two, I have a concern that I would like to add some more rules to our Leeward and Windward Planning Commissions. I just want to see where we're at with that.
Thank you, Commissioner Al. So far, we have just one item on your September agenda. And then as far as the rules go, after we get through bringing, well, we brought Epic system online, but after we get through familiarizing ourselves with it and getting used to the program, we'll shift our focus back to doing some rule amendments. The two rule amendments we're looking at as priority are to address Act 16 related to SMA and shoreline setback, as well as the rule, Commissioner Al, that you had mentioned regarding recusal of commissioners, and you suggested language from our Board of Appeal rule, and I looked at that, and so I will send you an email to see which sections you were referring to that you would like included in the PC rule. So those are the two main rules that we're looking at doing in the near future.
Are we going to get a clean copy of our existing rules as interpreted by the department after the last meeting, joint meeting?
Yes, you will. You should get those shortly.
Wave to the students.
Commissioner
Okay.
Parker, I think those rules just have to be signed by either the clerk or corp counsel, and then they'll go into effect shortly after that, and we'll provide you a copy.
Yeah, I've already signed them, so they've been, they're on to their next destination.
Mr. Chair, could I just say something really quick before we adjourn?
Yes, please.
I was hoping the students were on, but I guess they're off, but I'm hoping that they're watching the YouTube. I just want to tell you students that I appreciate you guys being here. Government is a very interesting process, and I appreciate you guys sitting in and listening in, and I hope to see all you students with us one day and get involved in government. So thank you guys, and I hope you guys are watching this YouTube. So thank you for being there.
Yes, we're looking for a new chairman.
As I can say, I hope I live long enough to see those students enter government.
Okay. So we had a motion to adjourn the meeting, but we had a last minute discussion. So all those in favor of adjourning the meeting, please say aye.
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 Aye. Opposed? The ayes have it. We'll see you in September. And don't wait till the night before to read all that 10,000 pages.
All right. Ahui ho, everyone.
Aloha.